Do you hold any personal data about individuals?
Yes, we do.
You need to know about GDPR. Some of you will already know these 4 letters that I'm about to mention, and some of you might be scared of these 4 letters already. GDPR. GDPR is a new law that comes into play on the 25th of May of 2018, basically protecting personal information. And it's been driven by the Human Rights Act. That's what's basically sitting underneath it. Okay, the European Convention of Human Rights, to be precise, because it's a European law. And it basically brings in a number of things into play, but one of the key ones is if you want to engage with people, you need their consent to do so, or another legitimate business reason to be holding their details. Under the old or current Data Protection Act, the maximum penalty that's ever been imposed is £400,000. Under the new GDPR, the maximum penalty is 20 million euros, or 4% of your global turnover, whichever is bigger. Yeah, one other thing just to make you aware of, under the current Data Protection Act, if somebody wants to do what's called a subject access request, which is basically I want to see my own information, they have to put it in writing, and you can charge them an administration fee for processing it. Under GDPR, they can phone up any person in your office, exercise their rights. You can't charge them anything, and you have to have done it within 30 days, or at the very least responded within 30 days to give you a justifiable reason as to why it's going to take you longer. And when I say provide their information, I don't just mean what's in your CRM system. I mean every email about that person, every recorded phone call, every bit of CCTV footage, everything. Every piece of paper, everything electronic, every single thing you have that's identifiable to that person as an individual is covered by this law. So it's a pretty significant thing. It's already been confirmed that post-Brexit we'll still be adopting this. So even if you're not in the EU, if you hold data on citizens who are in the EU, you're still covered by the law, even if you're not in the EU. So it's irrelevant to where you're based. One of the things that is very relevant is where's your data? Raise your hand if you use any kind of cloud-based software. Where's your data? Where's it actually stored? Is it in a country that's considered to have suitable data standards in place? By the way, the US doesn't by default. So if your data is being held in the US, you need to make sure that there are appropriate agreements in place for the specific provider you've got. You shouldn't be holding details you don't have a legitimate reason to be holding. You shouldn't be holding them for longer than you have a legitimate reason to be holding them for. Which, when you're in a business that's a lot of it's based on mining historical data, can be challenging, can't it? Because if you think you've got your, what I'm going to call your list has a lot of value in it. Someone moves house, you know somewhere between 5 and 10 years later they might want to move house again. You don't want to market to them, the month after they've moved house. They're not going to do that. But 5 years, 6 years, 7 years, 8 years, that's when they're prime. But if you haven't been keeping them engaged during that period, if you haven't actually got an ongoing relationship with them, what grounds have you got justifiably to 1, still have their data, and 2, actually use it? The answer is none.